Hi, everyone. Good morning. We'll start in just a couple of minutes. We're just waiting on a few more attendees. We'll just give it one more minute and we'll get started. All right. Good morning, everyone. And thank you all for being here today and for your coverage of this important case. My name is Dima Azizi. I work for CAIR New York, the Council on American Islamic Relations New York chapter. And I'm one of the attorneys for the plaintiffs in this lawsuit, Mahmoud Khalil et al. Versus Columbia University et al. This lawsuit was filed in the United States District Court for the Southern District of New York. The case number is 25 CV 02079. And this information can be made available if you contact the email address on the media advisory. I will be introducing the case today and the speakers that we'll have. We'll also have some time towards the end for questions and answers. So the plaintiffs in this lawsuit are Columbia University students and alumni who are challenging Columbia University's capitulation to the Trump administration. The lawsuit seeks to prevent the Trump administration from threatening funding cuts in order to force Columbia to suppress student speech surrounding Palestine. The lawsuit also seeks to prevent Columbia from complying with the federal government's unlawful demands and targeting its own students. Our first speaker today will be lead counsel on the case, Amy Greer, who is an associate at Dratel and Lewis law firm. Amy will give a background of the case, as well as what led to filing. After Amy's remarks, we'll have Zal Shroff, director of the Equality and Justice Clinic at CUNY School of Law, who also represents plaintiffs in this case. And Zal will share a little bit more about the legal landscape and the current status of the case. After that, we'll have one of the plaintiffs, Mahmoud Khalil, to share some remarks. And we'll also have Shay, although not a plaintiff in the case, is a current student at Columbia University and a member of Jewish Voices for Peace to share their experience on campus. We'll also have attorney Brittany Finley, who has represented student protesters at Columbia University, to share a statement. And finally, we'll close out with some questions and answers, some prepared questions and answers, and we'll open it to you all. And just one housekeeping note, please, as the speakers are sharing their remarks, you can feel free to put in your questions in the Q&A box. Just please identify yourself and the publication that you represent, and we'll try to get to those in the end. I'll now pass it to Amy Greer. Go ahead, Amy.
Thank you so much, Dima, and thank you everyone for joining us today. Oops, I glitched for a second there. Thank you so much, Dima, and thank you everyone for joining us today. Though this case might be complicated in a legal sense, the reason for the case is actually quite simple. In order to punish protected political speech it opposes, the federal government tried to subvert the Constitution's prohibitions against governmental infringement on the First Amendment by coercing Columbia University into becoming an arm of the government to identify, censor, and punish Columbia students for engaging in speech critical of Israel and/or supportive of Palestinian self-determination, dignity, and rights. This is called jawboning, where our government forces private actors to carry out its bidding to violate the U.S. Constitution. This case was filed to stop this unconstitutional incursion into plaintiffs' First Amendment rights. Though we filed this suit on March 13th, 2025, the reasons for this case began long before, and the evolution of that case took a turn that day. After October 2023, Columbia students began to speak out, demanding that Columbia and the U.S. more generally stop funding the genocide unfolding in Gaza. The students were organized and they were effective with their messaging, becoming the moral and ethical conscience of this country. And indeed, polling showed that the students' advocacy was in line with the majority view of Americans. Columbia became the focal point for the media, and most critical to this case, to the federal government. At first, by the ideological Republican-led House Committee on Education and Workforce Development, and then the Trump administration. They began to target Columbia students through the coercion of the Columbia administration. Those of us defending students in Columbia disciplinary proceedings noticed a trend developing. The more pressure exerted on the Columbia administration by the House Committee and later by the incoming Trump administration, the greater the crackdown and punishment on the students standing up for Palestinian life and liberty. Disciplinary rules were and are constantly changing. Punishments were and are being ratcheted up to levels not seen before on campus. And over the summer of 2024, a new speech policing office was created, the Office of Institutional Equity, a direct result of governmental pressure. On October 31st, 2024, the House Committee published a report they alleged to be about anti-Semitism on campuses around the country, but it was instead a mechanism to expose students for the sake of exposure and to further coerce institutions of higher education into capitulating to governmental pressure. Given the profound amount of surveillance on Columbia students at the time of the report's release, students were easily identifiable and thus further targeted with doxing and harassment. Critically, what we learned through that report was that the House Committee was sending threatening letters to Columbia and other universities around the country, demanding that schools turn over student disciplinary records for any and all students involved in advocacy for a free Palestine or opposing U.S. support for sending weapons to Israel. And in fact, the committee collected a mind-bending 400,000 pages through this process. The committee threatened Columbia's funding and further public humiliation if the school did not hand over the disciplinary records, and if Columbia did not start punishing its students more harshly for their their constitutionally protected speech. Through this litigation, we learned that there were multiple letters over the course of 2024, along with communications between Columbia administrators and congressional members and staff, which suggests that the pressure campaign occurred both in public and behind closed doors. All of this priming the pump for the incoming Trump administration ready to implement Project Esther. While all of this was going on, more and more students were being dragnetted into the OIE proceedings, facing transcript holds, suspensions, expulsions, and worse. Critically, students speaking out for Palestinian life and liberty, some of whom having lost so many of their family members in Gaza, Jewish students who felt compelled by their deeply held religious beliefs to speak out against the ongoing genocide, students of color whose consciences and sense of solidarity were so clear that silence was too great a cost. All of these students were being dragged through these processes while more records were generated about them, about their advocacy and their associational relationships. Again, those of us serving as discipline defense, along with the incredible students at Columbia, could see what was happening. Columbia was generating record after record and then handing them over to the government. So on February 13th, 2025, when the House committee struck again, sending another threatening letter, this time publicized, demanding that Columbia turn over yet more student disciplinary records and expel or suspend students with another veiled threat about Columbia's federal funding, a group of law students, myself, and a few attorney advisors got together to draft this complaint. CAIR and CAIR-NY courageously came on board to help file the complaint on March 13th, 2025. We had to hold the House Committee in Columbia accountable for their pervasive, continuous, and damaging efforts to silence students exercising their right to freedom of expression on a matter of great public concern. Notably, on March 13th, the same day we filed this suit, the Trump administration made good on the threats to put Columbia's head on a pike, sending a letter telling the school to make extensive changes to its campus policies, including adopting an expansive unconstitutional definition of anti-Semitism and punishing students harshly, or lose $400 million. And this was just the price to have the seat at the negotiating table. In that moment, the Trump administration expanded on the coercive pressure that began with the House Committee, and Columbia capitulated to serve as the government's hammer. We were compelled to add the agencies making such threats to the lawsuit in an amended complaint, and that was a prescient decision because as of July 2025, Columbia and the federal government signed a coercive contract, which includes more requirements that Columbia turn over student records to the federal government. In a March 2025 hearing before a court in the Southern District of New York, despite the government's arguments that there was no protected speech at issue in this case, which is simply wrong on the law, as Zal will explain in just a moment, the court determined that Columbia had to give plaintiffs and the court 30 days notice before handing over any more student records to the House Committee. And this is no small thing because the court recognized the incredible chilling effect that a dragnet demand for records had on the students' right to speech. Our job here in this case is to ensure accountability and, we hope, justice for these plaintiffs and for all students who had the audacity to continue to speak out for Palestinian life and liberty in the face of a U.S. government weaponizing their own university, the students' own university, to silence them, or, if they refuse silence, to ensure they were severely punished for that moral clarity. And this is exactly what the Constitution prohibits. And now I will turn it over to my colleague Zal to explain more about the legal facets of this case.
Thank you so much, Amy, and it's really great to be here with everyone. My name is Zal Schroff. I'm a professor at CUNY Law, and I'm one of the attorneys representing our Columbia students in this case, alongside Amy and Dima. And Amy gave us a background on the origins of this case. I want to take a moment to talk about where we are now, what the legal landscape is here, and what the significance is of the decisions our court will be making in the next couple of weeks. But before I do that, I want to start by talking about the importance of this case for the political moment that we're in. Because the Trump administration is using its regulatory power to intimidate and pressure civil society to surrender its values. It is counting on co-opting the power of our private institutions to prey on our people. And that's called jawboning, as Amy mentioned. It's where the machinery of the federal government is used to force our institutions to violate the law. Now, fortunately, we've seen that many of our institutions are fighting back. The American Bar Association, Harvard University, major law firms like Jenner and Block and WilmerHale, all of these massive institutions have taken a stance to fight this administration in court, to defend not only themselves, but also all of the constituencies that they serve. And they are winning those challenges that are a victory for the health of our democracy. Unfortunately, Columbia University, where I happen to be an alum, is not one of those institutions. Instead of standing up and fighting, Columbia has decided to cave. So this summer, Columbia made a Faustian deal. It has ensured that its own financial health is secured by agreeing to muzzle its students' self-expression or to simply arrest them into compliance with a Trump-imposed speech code. And it has paid the Trump administration hundreds of millions of dollars for the pleasure of being surveilled while it turns over student records for ongoing monitoring and scrutiny from the federal government. This is exactly how our institutions crumble. And for every ABA or Harvard during this time of constitutional crisis, there is a Columbia, an institution that is willing to surrender its values and turn on the public at a time when our government is attempting to exert authoritarian control. So the reason why this case is so important is because it does take on the Trump administration, it does take on Congress, but it also takes on Columbia itself. Because the US Constitution does forbid that kind of callous capitulation. It is illegal for private entities to allow themselves to be co-opted in this way. That is itself a violation of our civil rights. And we call this a state compulsion or a joint action theory of liability. And so let this lawsuit be a lesson to those institutions that are thinking about working with the Trump administration to achieve its unlawful ends. Let this be a lesson to institutions that would rather sell out the public than defend what is right. We will see you in court too. That is what this case is about and the significance of the case in these dark times. And so with that backdrop, I want to provide some more detail about where we are with this litigation and what to expect going forward. So the litigation focuses really on two critical time periods. First, when the Trump administration pulled Columbia's funding and demanded that Columbia adopt a series of anti-protest policies as a condition of any further funding from the federal government. That was back in March 2025. And Columbia gave in to most of those requests in just 1 week, including allowing a review of its courses on the Middle East at the behest of the federal government. And the other critical time period we're examining is this summer, when Columbia adopted the Trump administration's exact speech code banning criticism of Israel, and then signed an agreement hinging its financial future on enforcing that speech code. Since then, professors have canceled classes, and investigations into students for their political beliefs have continued to proliferate on campus, with the additional risk that the Trump administration may be receiving these records under their contract with Columbia. So we represent the students that are impacted by these profound restrictions on academic freedom. Our students have watched dozens of their classmates arrested, suspended, expelled, and their futures threatened if they dare to express a political stance against Israel's occupation in Gaza. And that is a violation of their First Amendment rights. Students are being chilled out of speaking their mind on topics of national and international importance because their government would rather that they be silenced. So we've filed a preliminary injunction motion before the Southern District of New York that demands two things. It demands that, one, the Trump administration can no longer threaten Columbia with funding cuts just to suppress free speech. And two, Columbia can no longer haul dozens of students into disciplinary proceedings just for criticizing Israel. And so we're waiting for the court to issue a decision there. And if we are successful, the court could immediately halt the threats that these students are facing here and open up Columbia to monitoring to ensure that it is in fact respecting its students' First Amendment rights. Now, at the same time, we're also waiting on the court to decide whether it will allow us to conduct early discovery to examine the communications between the Trump administration and Columbia during those critical weeks where Columbia caved, to assess whether, in fact, there was government coercion at issue here that makes both the administration and Columbia responsible for First Amendment violations. And those records are likely to include damning information about the dealings between Columbia and the Trump administration that the public has a right to know about. So that's our preliminary injunction motion, which has been pending before the court now for several months. But in the meantime, our legal landscape has really changed profoundly. Harvard won its case against the Trump administration, banning it from pulling funds to force policy changes on campus. UCLA's community has now won a ruling against the Trump administration, calling that investigation into student protest a sham and prohibiting the funding threats against UCLA. And then we also had the AAUP versus Rubio case, where a federal judge in Massachusetts has held that the Trump administration intentionally engaged in a campaign to terrorize and to deport non-citizens for expressing views critical of Israel, also in violation of the First Amendment. Now, that's the legal landscape as it's expanded. Meanwhile, conditions at Columbia continue to get worse and worse, with dozens of students still being carted before a disciplinary board just because they dare to take a political stance on Israel's actions. Columbia has made the remarkable assertion in this case that its students' harms are imaginary, that there is no risk of their students being targeted for their political expression or sold out to the Trump administration. Well, tell that to the dozens of students who have already been subject to these investigations and suffered the consequences for themselves and for their futures, let alone the potential data exposure if Columbia is in fact turning over their records to the federal government pursuant to their current agreement. Just last week, Shay, who is here to speak today, was sanctioned by the university. Shay is a Jewish student whom the university was brazen enough to call anti-Semitic just because they are a member of Jewish Voice for Peace and dared to publicly criticize Columbia's stance on Israel's occupation in Gaza. That is not normal, it is not okay, and it is certainly not free speech. So I want to close with what comes next, because by tonight, Columbia and the Trump administration will have to answer for why they have punished students like Shay and explain to the court how this case is any different than the case that students and faculty won at UCLA. That is pursuant to a court order from just a few days ago. And then the court is going to deliberate on the current motions in the coming weeks. And we'll keep you all up to date about these upcoming filings and any decision that the court reaches on these issues. But in the meantime, I really want to encourage you to continue reading the really damning information that is contained in the filings in this case. And we also have a package of the most recent filings available for members of the press who want to review that. And with that, I will turn it over to Mahmoud and then to Shay.
Thank you so much, Zal. Thank you, Amy and Dima. Good morning, everyone. I mean, let me start by saying if Colombia had the power to detain and deport me, they would have done that a long time ago to appease it is Zionist donors, Congress, and the federal government. And I'm not exaggerating by saying that because Colombia has already expelled and suspended over 100 students who were protesting a genocide. They've called the police multiple times to arrest its own students, all while protecting the Colombia affiliates who doxed and smeared these students. So the truth is simple, is that Colombia, represented by its board of trustees, was so happy to have the administration do the dirty work for them. Political pressure, congressional hearings, federal investigations became convenient tools for Colombia because it allowed it to suppress protest while pretending its hands were clean, and they were not. For a Palestinian refugee like myself, being admitted to Colombia was once a source of pride, and I believed in its history of scholarship and principled activism. But it did not take long to see that this commitment had limits, especially for Palestinian students like me and anyone willing to speak about Palestinian rights. So soon after arriving at Colombia, way before October 7, I had to go through shady processes with this administration to organize events advocating for the respect of international law in Palestine. And after October 7th, only intensified as students organized to demand that Colombia does not allow its resources to be tied to the killing of Palestinians in Gaza. The university chose to not to defend its students, but to appease this political pressure. And under pressure from Congress, Colombia surveilled, investigate, and punish students like me for speech that was plainly protected. And in October 2024, I believe students like me learned that records about us were turned over to Congress, and that Congress then published those records in such a way that some of my peers were identified, doxxed, and harassed as a result of that. So the constant pressure from Congress, from the federal government, from the Zionist donors, caused Colombia to open a speech policing office, as Amy said, called the Office of Institutional Equity. And Colombia exploited these bureaucratic mechanisms that were once used to protect students, but now being used to police speech, intimidate students, and suppress protest. I had to spend hours to over months defending myself against baseless allegations designed to exhaust and deter me and deter the other students. So the OIE has frightened many students into silence, as it was intended to do. And those students who remained steadfast in their speech and advocacy for a free Palestine have endured repeated harassment, surveillance, and punishment from this office solely because of their speech. So this was plainly repression, and we filed this lawsuit against Colombia and the House Committee and the federal agencies because institutions that suppress dissent, surveil students, and punish speech must be held accountable. And the right to protest, to speak, and to oppose injustice is not conditional, and it's not something a university has the way or the right to trade away. So really, this lawsuit is meant to hold all these actors accountable for infringing on my rights and the rights of my peers. And we bring this lawsuit in defense of all students and people, right? Follow their consciousness and speak truth to the people and hold power to account together. And let me end by saying that I will continue to seek accountability until every actor who was part of this conspiracy to deprive us from our rights are held accountable. Thank you so much.
Thank you so much, Mahmoud, for those profound remarks and for sharing your experience. Shay, if you can unmute.
Hi, thank you so much. Colombia's decision to sanction me for discriminatory harassment as a Jewish student reveals the true motives of its initiatives to fight anti-Semitism. I could talk for hours about the harm inflicted upon me through this disciplinary process. I'm certain that having to apply to law school with an open discrimination investigation that dragged on for months has affected my outcomes. I could talk about how isolating and upsetting it is to functionally be told that I do not exist as the person that I have always considered myself to be, as a proud practicing Jew who has now been labeled an anti-Semite for the crime of peacefully engaging with my own community. But I am not the center of this story, and I never have been. Colombia felt empowered to punish an anti-Zionist Jewish student because for the past 2.5 years, in complete alignment with the wishes of the Trump administration, it has punished Palestinian students with total impunity. I have watched my Palestinian friends be subjected to dehumanizing, grueling disciplinary processes for exercising their free speech rights. I have watched those kangaroo court disciplinary cases turn into direct attacks by congressmen and by the Trump administration. My career prospects are damaged, and my identity as an anti-Zionist Jew is delegitimized. But Palestinian students are locked in detention facilities, life milestones ripped away from them. I hope that the absurdity of my case serves to shed further light on the reality of Colombia's and the Trump administration's real aims, not to fight anti-Semitism, but to silence Palestinians and their allies at all costs. I used to think naively that the facade of fighting anti-Semitism would make Colombia hesitate to crack down on my speech as a Jewish student. And as such, I felt an extra responsibility to speak up and to amplify the voices of my Palestinian peers. Evidently, my Jewishness is no protection from accusations of anti-Semitism, but that only strengthens the imperative that I continue to speak up. I am afraid of Colombia, and I'm afraid of the Trump administration, but I am infinitely more afraid of the world that will emerge if I continue to let them silence me. I will speak up because it is my right and because it is my duty. Thank you.
Thank you so much, Shay. And your selflessness is truly inspirational. Just a quick reminder, if folks can post their questions in the Q&A box. We have a couple coming in already, but if there are additional questions, please go ahead and post them. We'll now hear from Brittany Finley.
Good morning. I am an attorney who for over a year has acted as an advisor for multiple student protesters at Columbia, and I have directly observed Columbia's Office of Institutional Equity investigate and sanction students for political speech under the pretext of addressing discriminatory harassment and anti-Semitism. Those investigations have converted peaceful human rights advocacy, including criticism of Israel and campus organizing for Palestinian rights, into formal allegations of discriminatory harassment. I have seen the harms of these practices up close. These proceedings terrorize students and cause real mental anguish in multiple ways. After March of last year, my conversations with students shifted dramatically to fears surrounding the physical freedom of international students pulled into disciplinary proceedings, concerns about whether it's safe to travel while OIE cases remain pending, and fears of retaliation if they come forward publicly with their stories. I have also witnessed the unique harm imposed on Jewish students, including a student who was brought to tears by the notion that they could be found to have engaged in anti-Semitism for expressing political views that Columbia appears to treat as incompatible with their Jewish identity. Shay's case is one example of a Jewish student subjected to the cruel process in retaliation for their political advocacy, but it reflects a broader pattern. I want to close by saying that what I have witnessed throughout representing these students is a systematic pattern of viewpoint-based discipline that chills speech and directly contradicts Columbia's professed commitments to freedom of expression and academic freedom.
Thank you so much, Brittany. I'm going to go ahead and read a couple of questions, unless anyone has anything else to share. Zal, Amy.
No, that's great, Dima. Please go ahead.
Okay. The first question is, doesn't Trump's definition of anti-Semitism protect Jewish students from harassment? Isn't this about protecting against anti-Semitism?
Yes, this is such an important question, so I'm really glad that it was asked. I want to be very clear that universities should be protecting their students from anti-Semitism. Punishing your Jewish students for criticizing Israel is not one of those ways. In fact, that's actually choosing to harm Jewish students for their for political expedience. And that's exactly what this is kind of about. The Trump administration is weaponizing anti-discrimination laws to actually target the very communities that are meant to be protected by these regulations. So Trump is invoking Title IX, which is a statute that's about gender equality, and using it to discriminate against transgender people under the guise of helping women. And he is invoking Title VI, which is a statute that protects against race discrimination, to clamp down on political support for the Palestinian people under the guise of supporting Jewish students. All the while, even Jewish students are being targeted if they're engaged in political speech that the administration doesn't like. So courts have actually already called this out in invalidating the Trump administration's actions here. The Northern District of California declared that, I have the quote here, even if the Trump administration were not trying to purge disfavored viewpoints from universities and was solely motivated by stamping out anti-Semitic harassment, the defendants may not accomplish that goal by coercing schools into adopting practices with widespread chilling effects on constitutionally protected speech. Well, the same thing goes here. There's actually a very clear difference between anti-Semitic speech targeted at harassing Jewish students for their Jewish identity and legitimate criticism of Israel. And there are definitions that mark that distinction with precision. The Jerusalem Declaration is one of those definitions. It's endorsed by over 200 scholars on anti-Semitism across the world, including many Israeli scholars. And it makes very clear that criticism of Israel and its policies in Gaza is not actually anti-Semitism. Columbia's policies could actually reflect that language. Why isn't it in there? Because Columbia actually is incentivized to stop students from talking about Israel because they are invested in preserving their relationship with the Trump administration. And so they are engaging in that kind of political discourse discrimination, and it's never actually been about protecting the Jewish students, as the case of Jewish students actually being targeted for these investigations reflects.
And let me quickly add, Zal, that Jewish students are an integral part of the student movement for a free Palestine. And this has been clear during the encampment, during the protests, during now, where we have also many Jewish students are being disciplined for their support for Palestine. So what's happening is, as you've said, is that conflation between, deliberate conflation between anti-Zionism and anti-Semitism, which is something absolutely, is not right. But this is why this administration and all these donors are pushing towards like the adoption of IHRA and similar policies.
Great. Our next question is, can you share whether Columbia has directly referenced the IHRA definition during any of the disciplinary hearings? Additionally, how many students have faced allegations of anti-Semitism since the definition was adopted?
Hi, yes, I'll answer this question. The answer to that is that yes, they have used the new definition in disciplinary proceedings since it's been adopted. The OIE policy has been revised to include the new definition. More so to that point, there are several cases where the only way they can reach the conclusion that any type of discrimination occurred is if they are referencing there's no logic to it if they're not using that definition to reach the anti-Semitism occurred because there are multiple cases where it's specific to a critique of Zionism. In addition to that, there are several. I can't name individual cases because some of them are still pending, but there are multiple cases, not just against Jewish students, but also against students of different backgrounds that have had allegations be brought against them for criticizing Zionism.
Okay, next question is, can you please give an update about where the legal process is on the suit at this stage? Zal, maybe you can take that.
Yeah, I'm happy to take that. So at this juncture, we filed the motion for preliminary injunction. The briefing closed in August, but a lot has happened since then, right? Both in the legal landscape and in terms of what's on the ground at Columbia. So the parties have been filing several letters with the court, providing updates about what's happening on the ground and what's happening in the legal landscape. So we're waiting on the court to issue a decision on the preliminary injunction. At the same time, the defendants in the case, all of the defendants, the Trump administration, Congress, and Columbia, have filed motions to dismiss. The court has to entertain those motions and also issue a decision as to them. So that's where we are in terms of the case posture. We haven't begun discovery in the case, but we are currently negotiating whether or not we're going to get early discovery to see some of those most important records between Columbia and the Trump administration. And that's a third decision point that the court has before it in the now. So we anticipate that in the next few weeks here, we're going to get answers from the court on all of these pieces, whether or not early discovery is going to be available, whether or not the motions to dismiss are going to be granted or denied in full or in part, and whether or not we're actually going to be able to get a preliminary injunction to stop the disciplinary proceedings at Columbia in the now while the case is pending.
Thank you. I do see another question. I would like to know, when did Columbia begin handing over disciplinary records to the government, and how many records did it hand over? We'll start with that.
Sure. So thank you for that question. I think it's really important. I mean, the ultimate answer at this point is we don't actually know the full extent of how many student records were turned over. What we do know is, like I mentioned in my opening remarks, during that October 31st, or in that October 31st report that was put out by the House Committee on Education and Workforce, we saw that a significant number of student records had been turned over. If you look at that report, the appendices of that report actually includes pages and pages and pages of student documentation of the student disciplinary records turned over. What we also learned from that report and through this litigation is that there were repeated requests from Congress for Columbia to turn over records. And we don't know at this point whether Columbia complied with that or not. But what we do know is that there seemed to be an ongoing backroom conversation happening between the committee defendants and Columbia that really implicates that many records were turned over. The other piece that I think is really critical is what records Columbia officially turned over to committee defendants early on in this process versus informal conversations where students may have been named or their activities may have been discussed with congressional members and their staffers in a more informal exchange of information that could have violated students' privacy, first of all, but also created this sort of cycle of ask and answer or call and response if you go to church. And that is really alarming. What we also learned in this litigation is the February 13th, 2025 2005 letter, Colombia had started turning over records at the request of committee defendants. They acknowledged this in court, that process had already begun by the time we filed 1 month later, which also means that they seemed primed to answer very quickly at the committee's behest, and implies that, again, there may have been a very consistent exchange of information. All of this is to say that's why we need discovery. That's why we need to fully understand the extent to which these exchanges were happening. And the last thing I want to say about this that I think is really critical is there are a couple of paragraphs in this alleged agreement that was reached between Colombia and the federal agencies that should alarm all of us, because they clearly indicate an intention of more data exchange and more disciplinary record exchanges happening this time between the agencies and Colombia. And so, again, we don't know the full extent. That's what discovery is for. But what we do know is that there has been a consistent exchange of information, that while Colombia has followed the letter of the law as to FERPA, the student privacy law, where they eliminated sort of direct personal identifying information, at least in their formal turning over of records. But we also know that because these students were under such heavy surveillance, doxing, harassment, that actually names didn't need to be published. These students were so heavily recognized that all the people had to do was read where they were, the date of the event, or something like that, and they were easily identified anyway. And so all of this just suggests that there have been a very consistent exchange of information, whether formally or informally, and I think the extent to that, will be further uncovered as we engage in the discovery process of this case.
Thank you, Amy. There was a question that came in earlier. I'm not going to read the whole thing. It's a little bit longer, but this case has national implications. So legally and politically, what is happening here is critical to our society's future. Can you speak to this reality? I think Mahmoud might be best suited to answer this.
Absolutely. And I mean, this case and other cases are being used as test cases, and the administration was not like concealing that. They said that this all is a blueprint. So it's really about whether the government can punish people for their political views, lawful views, and whether institutions like Colombia will stand up for their students and faculty or quietly allow that repression to happen. So what we're seeing is an attempt to set a precedent that speaking out, organizing, protesting, especially for Palestine, can carry the risk of detention, deportation, and the destruction of your future. So if that precedent stands, I don't think it would be limited to one issue or one community, like it's being used now as for Palestine. But we know very well that like it is now being used on other grounds. So it certainly will affect the future of protest in this country. So legally and politically, this moment matters because it will determine whether free speech is real and whether it only exists as long as it is convenient to those in power.
Thank you so much. Our next question is, how is this litigation unique in that it seeks accountability from a university for its acquiescence to the federal government? And is there any precedent for this kind of First Amendment case?
Yeah, I can begin speaking to that. So I would say it's a unique case in this moment, but there is legal precedent for challenges to private actors collaborating to violate people's civil rights. That's actually a function of civil rights law under Section 1983 and just the case law that has emerged from the federal courts on what it means to become a state actor, to adopt the unlawful policies of the government and take them on as your own. And so that theory of state actor liability that applies to private entities, that has been the law for decades. And there's a few theories to get there. There's state compulsion, as in the state has exerted power over a private entity to have it do its unlawful bidding, usually by economic coercion. That's one theory. There's the joint action theory, which is that actually the private actor actor wanted to commit the civil rights violations and collaborated with the government to facilitate that process. And there are a few other ways to make out those theories. We don't often see these cases. Sometimes we see them against state governments for working with private prisons and things like that. But we're in an unprecedented time of federal government coercive economic pressure. And so what we're seeing is actually this theory testing now against this administration. And that's why this case in particular is so important. Because what's different here is that every other institution, right, like Harvard fought back. Columbia chose not to. So it's now forcing its students to actually stand in the shoes of the institution to defend itself and defend the institution from this co-opting. That's what makes this lawsuit unique, but there is absolutely precedence in civil rights law that justifies this approach.
Thank you, Zal. One more question. How much support from the overall Columbia University faculty do you have for the case?
You know, the deal between Colombia and the administration touches a lot on academic freedom. Basically, Columbia University fully capitulated to the Trump administration by throwing, you know, academic freedom principles under the bus. That's why faculty are you know, like a big part of this, because one of the demands or one of the things agreed upon was like to restructure the Middle East department and other departments as well. In terms of support, we absolutely like got some like real support from faculty. However, also faculty are frightened by what's happening. We see less faculty being outspoken about what's happening because Colombia had thrown its faculty under the bus in front of Congress. They've tried to push some faculty out, and they're now also policing their own faculty with the OIE itself. So the OIE is not only targeting students, it is targeting faculty who are teaching about like the Middle East, about Palestine. We are aware of reports that some of these faculty members were investigated by OIE for simply mentioning Palestinian rights in their classes, for simply defining what Zionism actually is as a colonial project. I can understand, and like faculty at Columbia, they brought a case, the AUP case, with the Knight Institute that was won in Massachusetts.
Thank you so much, Mahmoud. We just have one or two more questions, and then we'll have two statements read aloud by two plaintiffs, by two student plaintiffs in this case who are proceeding anonymously. But before that, we have this question: what is the evidence that the Trump administration actually coerced these speech changes on campus?
Yeah, that's a great question. And so what I would say is this is actually a part of the argumentation before the court now. So Columbia and the Trump administration have made the incredible assertion that Columbia's policy changes exist in a vacuum, that they fell from the sky and they just happened to fall conveniently right after the Trump administration pressure. But what we're actually seeing is that the March 13th letter suspending the $400 million of funding at Columbia, that happens on March 13th. 1 week later, suddenly we have a new definition of anti-Semitism for discipline directly in response to the Trump administration. And then things are quiet for a little while. And then suddenly, right on the eve of the agreement with the Trump administration to restore Columbia's funding, we have an even more aggressive definition that bans all criticism of Israel being adopted. And that's just weeks after the lawyers for Columbia in this case represented that no, that's not the definition of anti-Semitism we've adopted. Those examples that you're giving are not relevant because, sure, a court has found the Trump administration's definition unconstitutional, but we haven't adopted that definition. And then not 3 weeks later, that definition is now Columbia policy. The only explanation for that is, in fact, the coercion. And so that's what we're teasing out in this litigation. But that's the direct line between the Trump administration coercion, Columbia's capitulation, and the harms that these students are experiencing. That is a direct line, regardless of what the Trump administration or Columbia are claiming in the press and in their filings.
Thank you, Zal. This is the final question. Why do you feel compelled to keep speaking out when you have faced so much backlash from both your university and the government? And I'm assuming this question is for one of the students.
Yeah, I mean, I think it's just a responsibility at this point. This is so much bigger than anything I, as an individual, am facing. We're speaking up because there is a genocide happening. And I think that all of us are very deeply rooted in that reality and in the fact that for all that we are going through, all the repression we face, it cannot compare to that. And we have a responsibility to our fellow students in Gaza to speak up for them. I think I also specifically feel really compelled to speak up so that Palestinian students on US campuses are not speaking alone, so that it is not up to the people who will face more consequences than I will to face the brunt of that alone. If I stay silent, they will face worse consequences, and those consequences will be done in my name. They will claim that students like me are being protected, and if I speak up, that narrative, that false narrative, is undermined in a way that is very important. So yes, there are consequences, but the consequences of not speaking up are just so much worse.
Thank you so much, Shay. Zal, do you want to take it?
Yes, happy to. And I know that Mahmoud and Shay have to leave for a class/other events, so please go ahead. But we wanted to close the briefing with just a short statement from two of our plaintiffs who are proceeding anonymously for their own protection that I think really highlight what's at issue here. So I'll begin with a statement from Sam So, that's one of our plaintiffs, and then turn it over to Amy. But this is from one of our plaintiff students. I'm disgusted that Columbia University would punish its students for expressing their beliefs, and even more horrified by its shameless compliance with the federal government's whims. I've come to realize that to paint the university as merely passive is too great a kindness. Columbia University is an active participant in the decline of free speech that we are witnessing today. We have experienced Columbia's disciplinary process firsthand. It is evident that the goal of the university discipline is to scare students into silence. But I will not be censored. The university can sell its own soul, but they cannot sell mine. If I am to finish my degree, it cannot be without demanding accountability. I hope this case can stop the underhanded methods the Trump administration and Columbia have used to stifle student voices so that other students do not suffer what I have experienced.
Thank you. And now from Sally Rowe. Columbia's collaboration with the federal government to stifle pro-Palestinian speech has not only made it impossible to grieve the mass death of my people, but also endangered me as a Palestinian student. The release of my records to Congress has exposed me to unbearable harassment, and Columbia's excessive discipline has made it impossible to express myself or my identity as a Palestinian student. I have witnessed firsthand the palpable fear among the student body to voice support for Palestine, fear that should have no place in an academic institution. This lawsuit is an invaluable step toward holding Columbia accountable for its systematic silencing of dissent.
Thank you both. So we will close out here. Just to say we are available for follow-up questions and interviews. You can contact the email address listed on the media advisory. I believe that is comms@ny.cair.com. and we'll be happy to answer further questions. Thank you so much all for being here today, and we hope to hear from you.
Thank you so much, everyone.